back if you're waiting on an announcement.
Go ahead, Therese.
Josh and I have met. We discussed Dr. Fabian's evaluation, and we've decided it's best if we get him to do a thorough report that Josh can then review, that we agreed to go ahead and turn over to him, although it was ex parte, and that he will visit with the family of the complainant and attempt to try and get this resolved before we go through the formal competency and sanity evaluations.
I would prefer to start the competency evaluation. If you guys want collaterally to handle that written report between yourselves, that's fine. But I don't want to delay the case, because once we put him into the competency road, it's still going to take us a little while before he gets evaluated.
I'll file a motion, and by the time he ever gets evaluated, we'll have Fabian's report done by then.
Yeah, we're actually moving a lot faster now. We have 11 new contractors that have come on board to do evaluation, so it's moving a lot faster. Like, I wouldn't be surprised if you can in under 45 days.
Well, and perhaps we can agree to let Fabian do the competency as well, since he's one of the county. If we did that, put him in the order.
I don't see why not.
I don't either. I'll ask Josh outside of the docket and see if that would work. I don't think there's any, if we're willing to give that up, since we've already had him do an ex parte evaluation, I think that'd be good for Josh.
Yeah. So then file your motion, put him in there, and I'll sign off on the order.
Okay. All right.
And I'll just leave it up to you and Dr. Fabian to schedule that.
All right. Okay.
That evaluation.
Yep.
Okay.
All right. That'll get done quicker. Thank you.
All righty.
Judge, can I approach you on Jacob Delgado, please?
Yes. What's going on, Mr. McRae?
Good morning, Judge. So I've conferred with Josh on this, and you're going to see a high setting. This is an unusual set of facts. Josh is new to the case, relatively new. This may be his second setting. And what we're having is he's needing to review this case with the complainants, and it's going to need to be an in-person conference. And I'm still working on getting some psychological records to Josh. So parties are asking the court for some time for us. So we're working on it, Judge, and it's not like we're not doing anything. So we'd like another conferring setting, if the court could see to that, to give Josh time to sit down in person with the complainants and for me to get some psych records to him.
Okay, let's do March 21st, Mr. McRae.
That'll be fine, Your Honor.
Thank you.
Thank you, Judge.
All right, I need to go on the record for this plea. Where's Mr. Clemens? Mr. Clemens, unmute yourself. Okay, you can stay unmuted. We're gonna go on the record on your case, okay?
Okay.
I'm gonna show you some documents on the screen. Can you tell me if you can see those documents? Can you see that?
Yes.
Okay, let's go on the record. This is cause number 2022 CR 0069W, the state of Texas versus Rosalio Clemens. Attorneys, please make your announcements for the record.
Samuel Laws for the state, Your Honor.
Al Alonso, Representative Rosalio Clemens, Your Honor.
Mr. Clemens is appearing by video conference. Mr. Clemens, can you please tell me your full name?
Rosalio Clemens.
Mr. Clemens, on the screen, I have the information that was filed in your case. What this document tells you is the charge that you have pending in this court, okay? And the charge is an assault family second offense. Before we get to the charge, I want to go over something else with you first. It's this other document that you signed called the Waiver of Indictment, Reading of Information and Rights. And what you're telling me when you sign this document is that you understand a couple of things. You understand that in every felony case, you have the right to the grand jury. That means that the grand jury reviews your case, they decide if there's evidence to indict you, and then they deliver an indictment to you. When they deliver that indictment to you, you have 2 days to review it with your attorney, and you have 10 days to prepare for trial. When you sign this document here, what you're telling me is you basically want to skip that whole process, and you have to give up those rights to the grand jury. Is that what you want to do this morning?
Yes.
Is this your electronic signature here at the bottom?
Yes.
So now I'm going to go over your charge. Your charge is a third-degree felony. It is punishable by confinement in the Texas Department of Criminal Justice, the Institutional Division, for any period between 2 and 10 years confinement. It also carries a possible fine of up to $10,000. Do you understand the range of punishment that applies?
Yes.
Are we proceeding as charged, State?
Yes, Your Honor.
Mr. Clemens, you have the right to a jury trial. You have the right to cross-examine all the witnesses against you. You also have the right to remain silent. Those are your constitutional rights. Do you understand those?
Yes.
When you sign this document here at the bottom of this page, what you're telling me is you're going to give up those rights that I just explained to you. Is that what you intend to do?
Okay. Yes.
Is this your signature where it says Rosalio?
Yes.
Are you a citizen of the United States?
Yes.
If you were not a citizen, I'm still required to tell you that a plea of guilty or no contest to this charge could result in deportation, exclusion from admission to the country, or denial of naturalization under federal law. Mr. Clements, are you satisfied with the representation of your attorney?
Yes.
State, there's no period of deferred here. What is the period that you're recommending?
It's 2 years, Judge. I'm not sure why it's not showing up.
Just checking, just making sure I didn't.
It's blank, but yeah, it's supposed to say 2 years.
All right. Mr. Alonso, does your client have a rational and factual understanding of the proceedings against him?
Yes, Your Honor.
Has he been able to assist you in the preparation of any defenses?
Yes.
In your opinion, is he mentally competent to waive his rights and enter into a plea?
In my opinion, he is.
I will accept the waiver of rights and make it part of the record.
Judge, I noticed on there it says no contact with Paula, but I thought that was changed to no harmful or injurious contact.
The bond was changed as part of the plea agreement you had made. There was a no contact, but we can change it to no harmful or injurious after our bond conversations.
Okay.
Because I think the parties are together, they've reconciled and they're living together.
I understand. All right, Mr. Clemens, I'm going to go over your agreement with you, and then I want you to tell me if that's your understanding of the agreement. The agreement is for a recommendation of deferred adjudication for a period of 2 years, no fine, no harmful or injurious contact with Paola Pereira. You have to complete the batterer's intervention program, and there's an affirmative finding of family violence that's made by agreement of the parties. We're going to do a TAP evaluation, and you have to perform 100 hours of community service. And you could do those through Bexar County Gives Back. If you're interested in that, my probation officer will give you the information.
Okay.
Is that your understanding of the agreement that you made in this case?
Yes.
Mr. Alonso, is that your understanding?
Yes, Your Honor. Did we talk about him being accepted in drug court or going? I think he was referred to drug court, and drug court was waiting for this plea for them to accept him.
Probation, do you have anything from drug court? As far as I know, there's still a wait list for drug court. So I can make it a condition of his probation, but there's a wait list. He still has to start probation, but there's a wait list as far as I know.
That'll be fine, Your Honor. But I think he's eager to get some treatment and help his recovery.
So as a condition of your deferred, I will order drug court if you are accepted. They usually wait until the TAP is back, but either way, he's covered. So he has to do the TAP, and I've ordered the referral, and I've ordered it as a condition. So he should be able to participate at some point. Otherwise, is that your understanding, Mr. Alonso?
Yes, Your Honor.
State, is that your understanding?
Yes, Your Honor.
Okay, Mr. Clemens, what is your plea to the charge of assault, family violence, second offense? Is it guilty, not guilty, or no contest?
Guilty.
Are you entering a plea of guilty because you are guilty and for no other reason?
Oh, I'm sorry, I don't understand. What's the?
Let me ask it another way. Are you entering a plea of guilty freely and voluntarily?
Yes.
Has anyone forced you to enter into
No.
this? Has anyone offered you anything in exchange for your plea?
No.
I will accept your plea of guilty. I do find the plea is voluntarily made, and I will ask the state to tender its proof.
State offers takes Exhibit 1 along with attachments.
Any objections?
No objections, Your Honor.
States 1 is admitted. Mr. Alonso, are you satisfied the state complied with Article 3914?
Yes.
I will sign the discovery acknowledgement and make it part of the record. Give me just a minute so I can read the exhibit.
Judge, I have finished conferring with the prosecutor in Sarah Redgate case.
Hang on, Mr. Redgate, I'm reading some exhibits.
Oh, I'm sorry, Your Honor.
Shannon, I sent you a chat.
Let's go back on the record, please. Mr. Clemens,
Yes,
I want you to pay attention. I'm going to tell you some very important things. I'm going to go ahead and get you started on your deferred today, but I want to see you back here February 24th because I want the TAP evaluation done and I want to take a look at it. The TAP evaluation is going to tell me where you are with the drinking, any substance abuse, I'm going to know, and it's going to recommend treatment. So if you are not participating in drug court by February 24th, I'm going to do something else about your treatment plan because I can't wait 3, 4, 5, 6 months for drug court to say there's an opening. I'm going to order the TAP. I'm going to put you on deferred today, but you're going to come back in February and we'll have a discussion about what treatment you're going to be doing. From now until I see you again, I want you to report weekly so that you can give a UA. Let me tell you why. The first assault that you got charged with was in 2017 and you didn't do good on deferred. In fact, I think they revoked you or they discharged you unsatisfactorily. And the issue back then was also drinking. And here we are again, the police picked you up and you had been drinking. So what do you think I'm thinking? That drinking is a problem, right?
yes,
Okay.
a lot.
So my goal is to help you and my goal is to get you on the right road. And the rest is going to be up to you. But I see it, I'm concerned. I'm going to put you on deferred, but we're going to do the TAP today. we're gonna order the TAP today. I'll see you back here February 24th. And depending on the status of drug court or whatever the TAP recommends, we'll have another discussion about treatment. Okay,
Judge, if the court please, Your Honor, if I may, I referred him to the Center for Healthcare Services, and he's been going to treatment since I got into case a couple of months ago. Plus, I got him a sober link. Every day he blows on this sober link, and he lets his wife know, and he was letting me know while he was on bond all the time. And he blows in it once or twice a day, and he sends me notice of it, and he sends his wife notice of it. His wife says, as long as he's not drinking, she doesn't have any problem with him. So we've already taken those steps to try to help him with his addiction.
well, I don't mind him continuing to blow into the sober link, but I still want to see him back here on the 24th for the results of the TAP evaluation.
Okay, and he's going to treatment with a provider recommended by the Center for Healthcare Services. He's going to treatment presently.
So if that's the case, it'll come out in the TAP evaluation, and the recommendation will mirror whatever he's already doing.
Good.
Okay, so I need him and you, Mr. Alonso, to go in a breakout room with probation so she can set up the TAP evaluation and give him instructions on how to do it.
All right. Thank you, Your Honor.
Yes.
Thank
Okay.
you.
Do you want me to sentence him today or on the 24th, Mr. Alonso?
No, you could sentence him today and let's
All
get
right. Okay, so hang tight.
2 years running.
Great. I do find the evidence is sufficient to substantiate your guilt. I will make no other findings. I will grant the application for deferred adjudication for 2 years. No harmful or injurious contact with Paola Pereira, Batterer Intervention Prevention Program, an affirmative finding of family violence by agreement, TAP evaluation, and 100 hours of community service. As a condition of your deferred, you will participate in drug court if you are accepted into the program and there is a slot open for you. And I will see you back here for the results of the TAP evaluation February 24th, okay? With that, we're gonna go off the record. Thank you. And you'll see an invite to go to the breakout room, Mr. Clemens. Go ahead and go there.
Okay, thank you.
Ashley, on Skipworth, I still did February 28th, just to keep it on the docket.
You read my mind. I was going to ask you.
And Judge, this is Suzanne. I've got an update whenever you're ready on Jacob Carrizales.
Yes, ma'am. Give me just a minute.
No worries.
Yes, Ms. Kramer?
Yes, Judge. We've worked out a deal between Jacob, myself, and Mr. Sandoval. He informs me that we would likely come back Friday morning to do the plea,
Okay.
which would be much easier for my schedule than doing it today, as I've got like 8 Zooms this morning. So
No problem. We will accommodate you. All right, we'll see you Friday morning, Suzanne.
thank
Thank
you so
you.
much, Judge. Oh, and this is by Zoom or in person?
By Zoom, yes.
Okay, thank you. And Jacob, if you can hear me, you can go ahead and leave and I'll talk to you about what we're doing. Thank you, Judge.
Thank
Bye,
you.
everybody. Bye, Ashley.
Your Honor, I'm back from conferring as well.
Oh, yes, Ms. Hernandez, go ahead.
We were going to stay on the trial docket, and then Josh was going to take a look at that motion if you have not ruled on it yet. So I told him I'd email it to him to see if he's agreed.
Yeah, I haven't rolled on it.
Then
But I
I'll.
will.
Okay.
I will get to it. You guys are on the trial docket. You want to stay on the trial docket? There's no resolving this.
Yes, Your Honor.
I am going to be calling cases from today for when we reopen up for jury trials. These will be given priority.
Okay, perfect.
So I'll give you a setting for February 28th. Hopefully we're reopen and we have a better idea of where we're at.
That sounds good. And I'll follow up with you if the state's unopposed.
Thank you. All right, Mr. Hernandez, we'll see you soon.
I have an
Mr.
update on Mr. Villarreal as well, Judge.
Yes, Mr. Peters, go ahead.
I was able to confer with Mr. Lyles. We have a motion to unseal some CPS records that I'm not sure if it's been ruled on yet, but we are agreed on that. If we can get that signed, then I can review the CPS records, and that may move towards a resolution.
Hang on, Mr. Peters, hang on. Bianca. Sorry, Mr. Peters, go ahead.
Yes, so there's a motion to unseal some CPS records that we were agreed on. If you can rule on that, then I can review those records. We also have a motion for speedy trial that's been on file, but we do just want to stay on the trial docket with this case.
Sorry. I see the motion for speedy trial, and you say you filed a motion to unseal records. I don't see that.
Yes, I can resend that to Ashley real quick, but it was filed and accepted on September 28th.
There's a motion for discovery. Is that the one? Is it contained within there? Oh, wait.
No, the motion for discovery was separate. It's a motion for discovery of records considered confidential under 26(1.201.
Yeah, well, I'm familiar with that motion. I just don't see it filed here.
Okay.
I can show you. Can you get David back on? I need to go back on the record, Ashley. Just have the motion for discovery. There's another motion for discovery. Oh, I see. They put motion for discovery, but it was something else. Okay, I will sign that right now.
Thank you, Judge.
And then you guys need to give me a protective order so that they can give a copy of those to you.
Okay.
Are the parties back? Is Mr. Clemens back? Yes. Let's go back on the record, David. I forgot to do something. Mr. Clemens, this is a plea bargain case. I did follow your plea bargain agreement. You do not have a right to appeal. Do you understand?
Yes.
Okay. Thank you. Now I'm done. Are you done with them, Bianca? No, okay, go back to the probation officer, please. Thank you.
And I believe other than that, Judge, that we just need to stay on the trial docket.
Yep. Well, except that, did they tell you if they have these records?
They do. I spoke with Mr. Lyles. I'll be going down to the courthouse or to DA's office to review them this week.
The order that is attached is just an order for a hearing. It's not an order granting. So I'm just gonna strike through the second paragraph and just grant it on there.
Okay.
Yes.
I'll give you March 21st, since you'll need time to review those. Okay, thank you.
Very much, Judge. Maybe excused.
Yes. Melinda, can you come get this order, and then the trial court cert I just signed I need to check one of the boxes.
Okay, I'm on my way.
Mr. Redgate, you had an update earlier.
Yes, Your Honor. We provided some documents, medical records and psych records to the prosecutors. And we would like a 2 to 3 week reset if possible, so they have a full opportunity to review those documents. I anticipate that after they have a chance to review it, that we will be able to get this resolved.
Did they tell you that?
They said, he told me that he's looking at a possible resolution.
Okay,
And I really believe we'll be able to get it resolved in the next round.
let's do February 22nd. That's a short week.
February 22nd?
Mhm.
Yes, Your Honor, that's fine. Thank you very much.
Thank you, Mr. Redgate. You guys are excused.
Thank you, Your Honor.
Anyone else need to update?
Yes, Your Honor.
Mr. Bancroft, sorry, I have multiple screens. I didn't see your hand up. Go ahead.
Yes, good morning to you, Your Honor, and Happy New Year. Your Honor, I have conferred with ADA Sandoval. We're going to ask for a longer than normal reset on this. I'm to supply the affidavits for 2 witnesses to him along with a video, and then he's going to want to bring the witnesses in. He said he would agree to whatever reset that you would offer.
Not a long one. I mean, this case is indicted. It should be ready to go to trial, right?
Well, the exculpatory evidence that I intend to produce, Judge, the ADA is very interested in it. And it does exist, Judge. I'm not blowing a smokescreen.
Mr. Clements, you're free to leave the meeting.
I'm sorry, how I do that?
There's a button.
First time
on
I
the
use
right.
Zoom, but okay.
Yeah, you can just leave meeting. You should see 3 little dots on your phone, and then it'll give you some options to leave the meeting.
Oh, okay.
Why do I think that your client has more than one case pending, Mr. Bancroft?
The other 3 in your court, Your Honor, were dismissed. She has a criminal mischief case in County Court 6 that is related to one of the cases in your court that was dismissed.
Okay, dismissed for what reason? For further investigation? Insufficient evidence, do you know?
I do not know, honestly, Your Honor.
All right.
I'm not sure exactly what we did. I have a file in front of me for the one we have today.
Did I sign those dismissals? Do you know?
Yeah, I believe that you did, Your Honor.
I
At one
found
time, she had 4 indicted cases in your courtroom, 2 assaults and 2 violation bonds / protective orders, and all 3 of those have gone away except for this one, which is the violation bond protective orders. And I just confirmed that with Mr. Sandoval. And then we have the other one that was the original assault case from way back in the day. That one was in County Court 6, and that one was dismissed. And the only thing pending in that court is a criminal mischief. It was a breaking of a cell phone. And I confirmed that with Mr. Sandoval this morning as well.
For whatever reason, I only signed 1 dismissal on.
The clerk's record shows closed, Judge, and I believe that was when we did the dismissals, I believe it was all part of the big thing, but so much water's passed under the bridge that's then and now. It's hard for me to recall.
Okay, no problem. So, sorry, the DAs are just gonna have to work a little faster than. I'll give you February 28th.
Thank you very much, Your Honor. And the docket call is still at the same time at 9:30, Your Honor?
Yes, you'll
Thank
get a link for that week sometime.
I do appreciate the consideration of the court.
And
Judge. I'm
where
really
is
hoping to
your
resolve it.
client? Where is your client?
Miss Norton, would you please say something?
I see her. I see her. Okay, until this is resolved, no more traveling, okay? Because I know you had several motions to travel. No more traveling, Mr. Bancroft. She needs to resolve her matters here. These need to be more urgent to her than to me.
Yes, ma'am. Thank you.
Okay, thank you. We'll see you in February. Ashley, on Rio House, what date did you give it? Did you give it any date yet?
Not yet, Judge.
Do you know what setting it is?
It's a second setting, Judge.
Set it for February 28th, please. Mr. Locke, I think I see your, and Mr. Cepeda and Mr. Combs.
Your Honor.
So Mr. Locke
Mr.
first.
Cepeda.
Okay, go ahead, Mr. Cepeda.
I've spoken to Mr. Sandoval. He's going to familiarize himself with the case. He's going to reach out to the complainant. The complainant is out of state, Your Honor, so we just probably need a normal reset. This is the first setting.
Okay, March 21st.
Thank you.
Thank you.
Excused. My client be excused?
Yes, sir. Thank you. Mr. Hobbs.
Morning, Your Honor. I've conferred with Mr. Lyles in the case. He's given us a new plea offer. Expires 2 weeks from now. So I think probably the best thing to do would be keep it on the trial docket. This is our, I believe, second setting. And then I'll notify Sam if my client, I've already told him I don't anticipate we're going to be accepting it, but obviously need to go over it and go over some evidence with them. That way we'll let the court know if my client decides to take it, but otherwise we can just come back to the next trial setting.
Okay, February 28th. Thank you.
Thank you, Judge. You have a great week. Mr. Jones, you can go ahead and log off. I'll call you shortly to talk.
Will, do you have an update?
Judge, I just logged on. I got stuck in 187. Sam and I have been talking. We haven't been able to come to any agreement, but I want to visit with him again before I announce. I've got Mr. Santos and Mr. Victor Flores is my client. He was late because I just didn't see, it was under Neil's name because Neil did the bond. And so that's why he was late, is because I didn't send him the link on time. But they're both logged in now.
Okay, I see him. Are you going to confer on both of those?
Yes, ma'am.
Okay. Not sure who has your cases, but Ashley will move you. Have we heard from Mr. Bunk this morning?
Kelly
Or-
checked in with the court, Judge. She's taking care of a plea. She'll be on after.
Okay, no problem. Thank you.